Swayam Prabha. Digital India. Educated India.
Dear students, welcome to the class of Transfer of Property Act. Today I am going to deliver 12th lecture. In 11th lecture, I have discussed about sale, seller and purchaser. In 12th lecture, today I will discuss the liabilities and rights of seller and buyer. That is section 55 of the Transfer of Property Act. Myself, Dr. Amrendra Kumar Ajit, Assistant Professor of Law, Faculty of Law, University of Delhi. So, let us start section 55, which mainly discusses about the rights and liabilities of buyer and seller. So, rights and liabilities of buyer and seller may be majorly divided into two parts. One is prior to sale and another is after the sale. Okay. So, in section 55, both types of liability and rights, that is prior to sale and after the sale, has been discussed. So, first of all, I will go through the glimpses of those liabilities and rights prior sale and after sale. Then after I will start discussing one by one in detail. So, first go through the glimpses of certain rights and obligation before the completion of sale. So, within section 65, if you will go through, then you will find that there are certain liabilities on the part of seller prior to the sale. That means, the person who is selling his immovable property, on that person there are a number of liabilities, number of duties, and these are the statutory duties. That is the main important part. These are the statutory duties and they comes in the form of covenants. If you will go through the previous slide, then it says that rights and liabilities of the buyer are statutory obligations and they work as covenants within the transaction itself. So, here we see that the seller's liabilities, first liabilities is to disclose material facts, second is produce the title deeds for inspection, then to answer question as to title, then execute a proper conveyance, then to take care of property and title deed, and last is to pay public charges and rent accrued. These are the seller's liability or duty. Seller's right is to take rents and profit. Okay. Then before the completion of sale, there are certain rights and duties of the buyer also. So, buyer liabilities are before sale, that is to disclose the materially increasing value of the property and to pay the price. Rights of buyer is to charge for price prepaid. Now, after sale or transaction, after completion of sale, there are certain rights and duties of the seller as well as of the buyer. So, first of all, seller liabilities. So, seller liabilities after the sales are this: first to give possession, implied covenant for title and to deliver title deeds on receipt of price. Seller rights after completion of sale is charges for price and paid. Then buyer's liabilities is to bear loss to the property, to pay outgoings like public charges, rents and taxes and all. Then buyer's rights is benefit of increment. Okay. So, these are the glimpses of sellers and buyers rights and duties prior to sale and after the sale. So, now one by one I will proceed in detail. So, first come to the seller's liability and rights before sale, and within that the first is to disclose material facts. It is a very important duty and obligation on the part of the seller, that seller will have to disclose material facts about the property. What are the material facts? Material facts are a very crucial facts with respect to that property, that if it would have been disclosed to the buyer, then buyer must have second thought, or he would have not gone through this transaction. Okay. So, those kind of things, if it has been not disclosed, then it may go under a challenge. So, better that in the beginning itself, because these are the statutory duties. So, seller is bound to disclose these kind of the material facts. Okay. Then further it says that these statutory duties are binding in nature. Buyer could not discover that defect without with ordinary care. Okay. Material facts are those facts where buyer cannot discover, that means it is within the knowledge of the seller only, and an ordinary prudence man, by going through that property, by going through that deed, whatever he has seen, he cannot identify those material defects. So, in that case it is duty, statutory duties has been laid down on the part of the seller, that it must be disclosed. Okay. So, in case of Floyd versus Booth, Chief Justice Tyndall says that the material fact must be of such a nature that it might be reasonably supposed that if the buyer had been aware of it, he might not have entered into the contract at all, for he would be getting something different from what the contract to buy. Okay. So, those are material fact, that means the fact which would have changed the decision for this transaction. Okay. Then that kind of the facts will fall under the category of material fact. So, example may be of the material fact, that there are certain encumbrances, charges, lien on the property, and there are certain restrictive covenants attached to that property. Okay, that if it would have been disclosed to the buyer, then certainly buyer would not have gone through this transaction. So, it may include the right of way, that means certain kind of easementary rights are attached with that land, and existence of nuisance in the neighborhood, that means there are certain categories of industries or something which is perpetual in nature, and that create nuisance near to the property, and it was not known to the buyer, but it was only known in the to the seller. So, it will become the material facts. Okay. So, second point is that to second liabilities which has been kept on the seller is to produce title deeds for the inspection. This is also a right of the buyer to go through the title deed of the seller, that it is a sale is a transfer of property, absolute transfer of property. So, when he is going to take that property, so it is his right that go through that okay, whether the property is proper or not, and title is proper or not, and title is proper or not, it can be seen only through the title deed. So, it has been said that it has been laid down in this provision that the seller is bound to produce all document demanded by the buyer for his examination. Okay. If the buyer does not demand any such document, okay, then the seller is under no duty to produce them. So, it is the willingness of buyer whether he want to see or not. Okay. So, it is a duty has been laid down on the part of the buyer, that if he will ask, buyer will ask, then only seller is bound to show, otherwise it is not that kind of the duty that he will certainly show those things. If he is not asking, that is buyer is not asking, then that means he is aware with the, it will be presumed even though he is not aware, but if he has not asked, that there will be the presumption that he is well versed with the title and he is satisfied with that title. Okay. So, buyer does not examine the title deed means he is satisfied with the authority and title of the sale and treated as a constructive notice of any defect. That means, if there was any doubt or any kind of defect in the title, then it will be presumed that because the buyer has not asked those title deeds, so it will be presumed that the buyer had constructive notice of it, okay, and he was satisfied with the title. So, he has not asked, it is a presumption. Okay. So, seller is not bound to show without asking by the buyer. Next point is to answer question as to title. Once the seller will show the title deed, okay, once the seller will show the title deed, then buyer will ask if there is any doubt about that, okay, and seller will have to clarify those doubts, because it is the complete transfer of ownership from seller to the buyer. So, buyer generally they want to satisfy themselves that there should not be any if and but in that particular property. Okay. So, whatever the suspicion is going to rise after going through the title deed, then he can ask not only merely from the title deed, even though if he is asking from any question with respect to that particular property, then seller is bound to tell or bound to clear his doubt. So, it has been said under section 55 1c that the seller is bound to answer the best of his information all the relevant question put to him by the buyer in the respect of property to its title. That means, whatever knowledge he had or have, in that case he will have to give those information to the buyer. Okay. Since the buyer is getting the ownership, he must be satisfied with the ownership rights of the seller, because the seller cannot transfer any title better than himself and not less than that title at all, because in 11th lecture I already discussed about it. Seller generally used to transfer his own title. So, whatever the title with the seller, that is going to be transferred. He cannot transfer the best title more than that, and he cannot transfer the less than that. Okay. So, whatever the title is with the seller, that title is going to satisfied with the buyer, that whether this title is sufficient or not, whether there are certain kinds of defects in the property or not. All these things should come with the inspection of the property, inspection of the title deed, okay, and up to the satisfaction of the buyer. So, since the buyer is getting the ownership, he must be satisfied. Then a mere inspection of the title deed is not sufficient. Okay. Mere inspection of title deed is not sufficient. If there are some doubt, buyer must ask them and the seller must answer them to the satisfaction of the buyer. The next liabilities on the seller is to execute a proper conveyance, because it is a transfer of property as a sale, and for sale we have seen that conveyance is very important where the price of the property is 100 or more. So, this conveyance is an essential part of the transfer of the property in case of sale, and this is done by signing of the sale deed, because conveyance is in the form of sale deed, and this sale deed must be signed by both the parties, not only by the single party, or putting the thumb impression on the sale deed by both the parties. So, duty of both the seller and buyers under this clause are reciprocal, both are under this, that when there will be the execution of conveyance, in that case they will have to execute conveyance and sign it. So, whenever buyer makes the payment, the seller has to execute a conveyance. Okay. That means, the buyer, once he has paid the complete amount and he has already paid the price, then conveyance must be executed and it must be on proper place and proper time. But what is proper place and proper time is not defined under the act, it will depend upon the circumstances, or it may be written in the contract for sale itself. Okay. Accordingly, it will be done. Then it must be within the reasonable time after the tender of the price. And what will be the reasonable time? It is also not defined. But one thing is that if seller is taking more time to execute the conveyance, then one remedy is, in that case what will happen? Suppose I have already paid price for the purchasing immovable property and seller is not executing the conveyance, and because time was not specified. So, in that case what will happen? The buyer may give legal notice by saying that this the time is the essence of this contract and it must be fulfilled within a proper time or within a reasonable time. Okay. And that can be done by on the part of the buyer. Then another important liabilities is to take care of property and title deed. Okay. Seller is bound to take care of the property and title deed. Why? Because once there will be agreement to sell, okay, and till the execution of the sale, in between what is the status of seller. So, at that time between the contract of sale and delivery of property or execution of sale, seller is bound to take as much care of property and all documents related to that property what is in his possession as an owner of ordinary prudence would take such property and documents. Okay. So, it is the duty on the part of the owner that he will take care of the property as well as document, and he will keep it safe, property plus document, okay, after agreement to sell. Next is to pay public charges and rent accrued. That is also important part on the part of the seller liabilities. That means, when once he is going to transfer the ownership to the buyer, then most favorable condition would be that that property must be free from all encumbrances or it must be known to the buyer. Okay. If buyer is agreeing with those encumbrances, those charges and all, then that is not a problem. But it has been said that first of all it must be public charge and rent must be paid by the seller. So, seller is bound to pay all public charges, rent, taxes, etc. before the date of the sale. Even the interest on all encumbrances on such property due on such date. Okay. So, this is the one of the important part on the part of the seller. If the seller is not doing this, then what will happen? Then it is a general clause, it remains in the sale deed itself that if something is going to be known to the buyer later on, which was not earlier known to the buyer and it was not disclosed by the seller to the buyer that there was certain charge and encumbrances, taxes on this property. So, even after the sale, seller is bound to pay that amount, okay, and he cannot say that now the property has been sold and he will have no responsibility. So, before the date of execution, whatever the kind of charges and encumbrances on property will be, that will be paid by the seller even after the sale of the property. Now, then come to the seller's right, and this rights is before sale. Okay. So, right is here 1 according to section 55(4)(a) clause A, subclause A. It says that to take rent and profits. To take rents and profit means that once the agreement to sell has been signed and before the execution of the sale, seller will have right to take rents and profit, he will not stop it. So, seller is entitled to the rents and profit of the property till the ownership of its passes to the buyer. Okay. So, in between that period, that is from the contract of sale to the execution of sale, seller will be entitled to take as it is he was taking that rents and profit. Sale is completed when the ownership is transferred to the buyer, and the ownership will be transferred to the through the sale deed only. Transfer of possession is one of the essential criteria, but only possession may be taken of the property even prior to the sale. Okay. So, that will not treated as the transfer that is happened in that way, unless and until there is a execution of the sale deed. So, till the ownership is transferred, the seller continue to be the owner of the property, and in that capacity he becomes entitled to the rents and profit of the property, because ownership has been not changed. So, till that time the seller has every right to enjoy the profits of the property. Okay. So, he is the true owner till the date of the execution of sale deed. Then next is buyer's liabilities and rights before sale, that what should the buyer should do prior to the sale, what are the liabilities and rights. So, buyer's liabilities first is to disclose the material facts increasing the value of the property, because he is not bound to disclose the material facts with respect to the property, that is the duty of the seller. But the buyer is bound to tell to the seller about the materially increasing, or if he has any kind of information which is not known to the seller, that his property value is going to increase sharply and drastically in coming weeks or coming months due to certain policy changes or certain things in the market, that must be disclosed to the seller. Okay. So, liability of the seller is limited to only those facts which relate to the title of the interest of the buyer, and only he has that knowledge, not beyond that. So, in the case of Summer versus Griffiths, one old lady contracted to sell a property at much less price, believing that her rights in the property were not absolute. So, it was her presumption that he had no absolute right with respect to that property, but the buyer was knowing that she had absolute right over the property, and that was not disclosed to her by the buyer. Okay. So, buyer purchased that property, and that lady, that seller, was under influence that she had no good title over the property. So, it was held that it was a kind of fraud and sale was set aside. So, if things were very known to the buyer and buyer had not disclosed those things properly on time to the seller, in that case there will be it will be treated as fraud. Generally, it's happen that those builders, those real estate agents who are purchasing properties from the farmer, they have very advanced notice about number of projects, number of things what are going to happen under the town planning, and accordingly they used to purchase that property. So, they have a vast knowledge about the upcoming projects and all, but the seller might not have all this kind of information. Okay. So, seller is not aware about that what is the future of his property and what will be the future value of his property. So, in that case what he will do? He will sell the property on the current land rate or whatever it is going in the market, not on the basis of the prospective increase of the value of the property. So, in that case later on it is going to be known to, then he may challenge that whatever he delivered, whatever the price has been fixed, that was not proper, and it was the buyer was well aware. If the buyer was not well aware, then it will be not a problem, but if the buyer was well aware and it has been not disclosed to the seller, then it will create problem, and it may create or it may violate the principles of fairness, and in that way it will be treated as fraud and contract may be set aside. Then next liability or duty on the part of the buyer is to pay price, because it is before sale. So, whatever price has been fixed, okay, and I told you in the last class that price cannot be unambiguous, okay, price must be very clear, because money is only consideration in case of sale. So, where the money is only consideration in case of sale, then that price or method for calculating the price must be declared in contract to sell. Otherwise, again it will be a ground for violation, okay, and contract may be repudiated. So, the buyer is not bound to pay the full amount before the transfer of the ownership. He is not bound. He may either pay price or promise to pay at the time of completion of sale. The buyer is not bound to pay the price until the conveyance is executed. Once the conveyance is going to be executed, before that he will pay the price or after he will pay the price. Okay. So, buyer is not bound to pay the price until conveyance is executed. That means, generally it happen on the same day, both things happen. Some amount of money is already given to the seller and buyer gives the final amount of money just on the date of the execution of the deed. Then what are the buyer's right? Buyer is going to purchase the property, then what are the rights before the sale? So, first is to charge for the price paid. Okay. It has been said that according to the subclause 6 subclause B, clause 6 of subclause B, that the buyer is entitled to a charge on the property unless he has improperly declined to accept delivery of the property as against the seller and all person claiming under him. So, whatever the to charge for price prepaid, that means whatever it has been paid as a part payment or something like that, then for that he may charge, and this charge is a statutory charge in favor of the buyer and it is different from the contractual charge to which the buyer may become entitled under the terms of the contract. So, buyer is entitled for that charge for the price which has been prepaid. Now, these were the before sale rights and duties of the buyers and seller. Now, second part is after completion of sale, that once the title deed has been executed, then what are the rights and duties of the seller and buyer. Okay. So, after completion of sale, that is what are the seller's liabilities. So, I have discussed earlier the seller's liabilities is to give possession, to implied covenant for title, to deliver title deeds on receipt of price. Seller's right would be charges for price unpaid. Then buyer's liability will be to bear loss for to the property, to pay out goings, and buyer's right is benefit of increment. Okay. So, in that case we will see first of all seller's liabilities. What are the seller's liabilities? Seller's liability first is to give possession. That means deed has happened, sale deed has been already done, price has been paid, then the next is to give full possession of the property. Okay. And this is a very important part of the transaction. Okay. Unless and until the property is not going to be possession is not going to be given, then how the transfer will occur. So, it has been said the seller is to give possession of the property either to the buyer or his authorized person whenever the buyer so requires. Okay. So, generally buyers used to take possession on the day of the execution itself, unless and until it was already contracted that something it may be delayed or something 1 or 2 days or 1 month like that, it will be the mutual understanding between buyer and seller. But rule is that possession must be delivered just after the execution of the sale deed. The delivery of possession will depend upon the nature of the property to be transferred. Okay, that what kind of property has been transferred, then how it will be delivered. Suppose because pond has been transferred, forest land has been transferred. Okay. In that case, how the possession is going to be transferred. So, it has been said that in case of tangible immovable property, the physical control is to given over the property. Okay. Physical control, that means now you will have to control to regulate that property. That means possession has been delivered. Suppose pond has been transferred. So, how it will be treated, that it is within the possession of the buyer. That means now the buyer will have right to give auction for the selling of the fish from that particular pond. Okay. So, catching the fish from the particular pond, if a right that has been given to anyone by the buyer, that means buyer have that kind of possession. In same way, it has been said that if the property is intangible, immovable property. I told you in the last lecture that immovable property may be tangible and even intangible. It is very clear for the tangible immovable property, just like any building, any kind of land, forest and all, these are the tangible, we can see it. But intangible, which are not visible, which we cannot senses through our 5 senses, in that case that kind of the property is also immovable property, it has been kept. And just like any kind of IPR, whether it is trademark, patent, copyright and all, these are treated as intangible, okay, intangible immovable property, and their transaction also governs through the Transfer of Property Act. So, the possession is symbolic. Possession is symbolic because it is intangible in nature. No one can possess, no one can hold it. So, generally that the rights related to that particular property, if the buyer is enjoying, then it will be treated as that things has been transferred. Just like take the example of in the case of copyright, okay, that the copyright is going to be transferred to other person, that means the person may broadcast it, may copy it, may publish it, that right is going from the seller to the buyer to the purchaser. So, in that way it works. The possession is to be given after the ownership is transferred to the buyer. This means that the date of execution of sale deed, if there is no contract to the contrary. I have already told you that on the date of execution, general practice is that on the date of the execution itself, it will be decided that this property should go, or that this property will be transferred to the buyer. But if there was certain contract that no, it will be transferred later on or something like that, or the possession has been already taken even prior to the transfer, sometime it has happened that possession has been given, but execution of deed will happen after 1 year, after 1 month, 2 months, 6 months, 1 year also. So, because there is no time limit in this, okay, that within what time frame it should be, it is a reasonable time. But even the buyer and seller can fix the time of the execution in the contract to sell itself. So, contract to sell, once they are signing, generally they used to fix the timing also, that before this date sale must be executed. Then second is implied covenant for the title. Okay. Implied covenant for the title. The interest which the seller professes to transfer to the buyer subsists, and that he has the power to transfer the same. Implied covenant for title itself says that such covenant is implied in every sale of immovable property, and it is not required to be expressly mentioned in a sale deed. That means, whatever the title seller had, okay, that title may be transferred, but by the buyer also later on. Okay. So, that is implied covenant for the title. That is means that the ownership which is attached to the particular that property, that is going to be transferred to the buyer, and same title is coming to the buyer, which may be sold later on to any third person or second person, okay, as it has been purchased from the seller. So, same title is going to be transfer with respect to that property in every subsequent sale of the property. So, such covenant is implied in every sale. It is not necessary that it should be mentioned in that. Okay. So, it is so important in that it is not necessary even to be mentioned that whatever the right belongs to the purchaser, the same right which has been came from the seller to the buyer. Now, the buyer will become seller in future and subsequently another buyer will take the same right as it was transferred by the first seller. Then legal effect of such covenants are: first, covenant implies absolute warranty of title in this case. Then this liability is limited to which the seller professes to transfer. That means, he cannot transfer the better title, he cannot transfer the lesser title. Okay. So, the whatever the title seller had, the same exact title will be transferred to the buyer. If a defect is found in the seller's title after completion of sale, the buyer would become entitled to sue for damages. I have already discussed this point earlier. Then further it said that the covenant runs with the land and it is enforced by the subsequent purchaser of the land. Okay. Covenants, that means the title, what kind of the title, what kind of the ownership is attached with, that will run with the land. That means, the owner will have same type of the covenant for the subsequent buyer. Okay. And subsequent purchaser can enforce those things later on. Later on, that means that whatever the buyer has sold, the same thing should go to the, sorry, what is the same thing has been sold by the seller, the same thing should be go to the buyer, and buyer will sell subsequently. If something has been lacked in that case, it will be enforced by the subsequent buyer. Then third point is to deliver title deed on the receipt of the price. This is the last one in the seller's liability, because he has delivered possession. Now, after the price payment and all and execution of deed, original document, original ownership paper must be delivered or must be executed to the buyer. Okay. So, where the whole of the purchase money has been paid to the seller, he is bound to deliver the buyer all documents. Okay. So, within the deed what will happen? That means, whatever the original document was with him, okay, original document ownership paper, that will be given, as well as this agreement